Alright everyone, we start off today with an important win for free speech, but it is a limited and qualified win. It's a preliminary injunction in the Missouri versus Biden case, and there's a link in the description. I'm not going to go through the entire thread, but it lists, and it's accurate, I checked the docket as well, lists accurately a number of provisions as part of that preliminary injunction in this particular case against Joe Biden's administration, various federal bureaus, etc., etc. Now, what it's pertinent to is things like the Twitter files, some of the shenanigans we saw with the censorship of the Hunter Biden laptop case, etc., etc. For a number of years, what we've had in the United States is that the U.S. government has unconstitutionally been attempting to use workarounds to the First Amendment in regards to the internet. So the fact that a person is putting something out that is objectionable or considered to be false by authorities, whatever that means, is not pertinent to whether it's still protected speech. A person in the United States, a U.S. citizen or lawful resident, has the right to weigh in on any political issues they want. There are very, very few stringencies with regards to speech, online or otherwise. You can't credibly threaten people. You can't openly defame people, libel, and so forth, depending on whether it's spoken or written. And then there's non-speech, like spamming or botting. Of course, spamming is effectively a heckler's veto. It's attempting to rob others of their lawful speech, and robots don't have free speech rights, at least not yet. Now, look for them to probably try to change that in the future. It'll be very interesting. Cybernetics for the win, man. But you should definitely take the link and look into this. What this has to do with is that the U.S. government said, well, we can't censor U.S. citizens, but there's a big pile of Russian disinfo and stuff like that. There's mean tweets exist. I know what we'll do. We'll pressure those companies to take care of the problem for us, despite the fact that we also, in some states as well, California notably, we grant subsidies to these companies. We openly coordinate with them for various technological purposes, and in some cases even grant them taxpayer money to develop things, like Google is famous for working with and for the U.S. government. Despite that fact, we have every right to coerce them, suggest rather, that they ban a user, that they remove a post, that they block a term in the algorithm, something like that. Now, this preliminary injunction, keep in mind, is a preliminary injunction. It effectively temporarily rules against Joe Biden and much of his bureaucratic, tyrants that he has hired, and prevents them from doing this. Here's the problem. First, we don't know how it'll play out at a higher court level. We're not exactly sure whether the preliminary injunction is even indicative of the fact that in the end, the Biden admin will lose the case. It could never make it before Supreme Court. The Supreme Court could refuse to hear the case, which often happens actually, even when there's a very compelling reason. If anything, SCOTUS is often too reluctant to take up cases. It can be good, it's judicially proper, but at the same time there are a few egregious examples of the SCOTUS dragging its feet on necessary issues that really probably should have been, fixed years before they ended up being fixed for a final decision. We're not sure how they'd rule. They could rule in favor of the, ironically, with a narrowly conservative court, they could rule in favor of the government and say, well, they didn't force any businesses to censor anyone. You're using the term coerce, but we can't establish that there was coercion. They simply suggested it. In which case, that'll go on for literally, till the end of time and the uniparty become permanent. I have a feeling that they would rule in favor of the state of Missouri, etc., the various plaintiffs in this case, which is the good thing. But it'll take time. The court process is deliberately very, very slow in the United States, which is why, most people settle out of court when they are convicted of a crime. They're like, well, indicted for a crime. They're like, well, I don't have the time to litigate. I don't have 5 months and, the $100 grand I'm going to have to pay a decent, competent lawyer to represent me for, the length of time I'm going to have to litigate, so I have no choice but to settle. They're offering me a plea deal. Most people just take it, just to be clear about how U.S. justice works, and that's in the criminal sense. Civil courts can be even slower. So we'll see what happens. But as far as the preliminary ruling pertinent to the injunction, very good. It's proper. The U.S. government does not have the constitutional authority to ignore the First Amendment, nor should it be construed as having the authority to work around a constitutional amendment by going through others. By the way, the handful of conservatives, so-called, that don't have a problem with it because of the technicality that the Biden administration never forced Google or Twitter or any of these other companies to do anything. Okay, well, what if the U.S. government strongly suggested to gun manufacturers that they should start manufacturing something other than guns, and then effectively winked, nodded, and threatened mafioso-style retaliation if they didn't? Well, that would be a little bit of an end run around the Second Amendment now, wouldn't it? What about the right to privacy? Well, the government can't spy on you without a warrant directly, but third parties certainly can. Well, we're banning end-to-end encryption, and we're forcing them to store all DMs that are ever made, and then we can just ask them, hey, user 123 over here, we suspect that he might be a shady character selling crack on the internet. Well, we're going to need to see those messages if you know what's good for you. Look, it's like a protection racket. It's mafioso style. It's like Gangland America. Clearly it's wrong. The Twitter files thing never should have existed. There shouldn't be any coordination between the government and private entities with regards to this. It's been going on forever, long before the internet existed, and it will continue to go on long after this, even if this case is a win. That's the other caution. The other reason to be a little bit more sourpuss and pessimistic about this, other than waking up at 6 o'clock in the morning, thank you, baby, and thank you, cats. The other reason is that because the government is doing it entirely behind closed doors, you have to have a company that's willing to disclose the fact that they were, coerced, effectively, in order to have any case at all in the first place. Well, some of these companies are completely in favor of government censorship. They're not going to tell all. They're not going to tell, basically, they'll just have a trusted individual in the company. They know that isn't going to rat them out. And that trusted individual just happens to be trust and safety or something like that, and then makes that further suggestion to members of their team. Or pulls the trigger themselves on a user and bans them. You're never going to find out because, the person there is probably being paid by the government. Again, how can you establish even a civil case unless you can establish that there are actual plaintiffs in the first place? And how can you do that if the person's willing to cover their tracks and being paid by the government through some sort of extra legal means in the meantime? So, it'll keep happening. It'll just slow it down. It's a positive decision if they, in the end, they side with Missouri. That's good. There's nothing bad about it. It's a win for free speech on the internet. At least it delineates that it's illegal, but it will keep going. The government engages in illegal behavior on a day-to-day basis anyway. It doesn't matter whether it's related to your First Amendment rights or any of the others. Every day the NFA exists, the Second Amendment is being violated, but there aren't any major court challenges that have ever made it high enough to make an impact on that. In the wake of Bruin, we might get some recourse at some point, but again, the judiciary is slow by design. That's about all. Peace out.